some trees and bushes that are overhanging sidewalks. That when I'm walking the sidewalk, I got clothesline, kind of jab me, and there's some of the railings that are up to code with the Americans with Disabilities Act.
Hey, Charlotte, you know?
You'll have to get the plan that's on it.
Isn't that on the street behind us?
Should be.
He's gonna find the address for you.
Okay.
We have the district attorney, we have the clerk's office, we have the juvenile office, we have,
Probation.
yeah, probation office. Actually, it's on the side of the building.
Do that.
Probation.
Okay, you'll have to take all the electronic devices back to the vehicle. They're not allowed to do it.
I don't have the vehicle.
Okay, well, you can stand here, wait.
Who?
Your friend? Here?
Talking about the bushes.
Okay.
Well, I'm not going to be responsible for his equipment.
Yeah, I can't see, so I use my devices to help me communicate. So under this covered in the Americans with Disabilities Act for effective communication.
Well, the Superior Court judge has actually ruled that no electronic devices, Bluetooth devices or anything are allowed in the building.
Does that supersede federal law?
No, it does not.
Okay, so the federal law is the Americans with Disabilities Act. Do you have a court order or what is
Yes,
that?
we do have court order.
Can I get a copy
You
of
want
that?
it? Okay.
Yeah, great.
270. Can I give you 21?
You said you wanted to know about the bushes and all that stuff around it?
No, I was going to inform somebody about the bushes and the
Okay, you
handrail.
have to do it at the county office, which
Okay,
is
what's
down on the Gow Road.
Is it here in town?
It's on the Gow Road. It's on the south of town.
Okay, cool. And what office is that?
It's the county office.
That's just called the county office?
Yep, it's the county building.
Oh,
You
okay.
have to go in front of the, talk to the county manager.
County manager. Is there a building manager here?
He is,
No, there's not a building manager.
Okay.
Maintenance?
I just try to handle at the lowest level without going up the chain.
Yeah, I mean, that's where all the county building inspection officers.
Security or?
yes, we are.
Okay. Are you just security guards or law enforcement?
We are sworn law enforcement deputies with Randolph County.
Okay. All right, cool. Well, we'll find out if they want to be law enforcement or rule enforcement today. Because judges don't make laws.
That's right.
We learned this back in civics class.
Absolutely.
Legislative branch does that.
Are you just...
Oh, okay. Can you read them to me?
No, you can have a copy and you can read them. There's copies out here.
Oh, okay. I can't actually. I can't see to read them.
It's his. Now you're going to live in the courthouse.
Captain Lanier.
Are you just living in the...
Captain Lanier.
Manier? Badge number?
So I don't have.
ID number?
There's a copy of the orders there.
ID number?
What y'all here today for?
You have an ID number?
Request the clerk's office.
Okay.
Yeah.
If you want to come through security, second floor of the clerk's office, they'll be glad to help you.
Okay.
Records are up
You guys
there.
are going to deny me access with my assistive device?
Yes, sir, that's correct.
Americans
So court
with
order.
Disabilities Act?
Yes.
You are?
You are familiar.
Does this supersede the federal law that is the
Yes,
ADA?
it does.
Exemptions on the court order? Can you check to see if there are any exemptions?
That's the court order right there.
No exemption.
That you just threw on the ground.
Can you check to see if there are any exemptions?
There's no exceptions, sir.
No exemptions.
If y'all want to come in, if not, I need to get out of the way from the traffic.
There's no traffic, sir.
What traffic?
Or you see somebody?
If y'all want
Are
to
you
like to get the
seeing?
clerk's
Are you
office,
seeing
second
something?
floor is the clerk's office, okay? That's for the
Okay,
record.
so you're refusing me service because I'm using assistive
No, I'm
devices?
not. We're not.
Absolutely, absolutely
I want to be
refusing.
clear. I want to be clear. You're refusing me access unless I surrender my assistive devices.
No, you're not surrendering. You can take it back to your vehicle.
I don't have a vehicle. I don't have 25 cents.
Okay, that's fine.
Nobody wants to identify.
He seems to be writing something down. I don't know what it is, but I think they think it's a joke or something.
Yeah, you guys realize that your qualified immunity for violating civil rights, you lose qualified immunity, meaning that you guys are liable. What is that?
Bull.
There's a list of the officers here.
What is that?
He asked for
Is that
this.
names?
Oh, I asked for names.
Is that names?
Why you keep trying to hand me stuff?
Can you read it to me, please? Sir, I can't see to read this. Will you read this to me? Do you think your actions are appropriate? Are you proud of your service right now?
They don't care, man. That's the problem.
You go today?
Wow.
All right. Well, we got service denied because of disability. They're not willing to recognize that federal law trumps some local policy.
A judge trying to make law.
Actually, one of them did. The lady did. She did recognize that it trumps it, but she doesn't care.
Yeah.
She'd rather enforce the local policy than the federal law, even though she recognized that federal law trumps the policy.
When you come off, survey to your right, okay?
Lawsuits aren't just for the victims, they're for society. When one person stands up,
The courthouse is quiet in the way only government buildings are, not peaceful, controlled. Sound doesn't echo here by accident. It's absorbed, flattened. Voices lose their edge before they travel far enough to matter. He enters slowly, not cautiously, deliberately. Every step is measured, not because he's unsure, but because his body requires it. What he carries with him isn't optional. It's not convenience, it's access. Without it, the building might as well be sealed shut. At first, the exchange feels procedural. Directions are offered, movements are suggested, hands gesture towards spaces he cannot see. No one notices the mismatch, or they notice and move past it. Either way, the result is the same. The gap isn't physical, it's perceptual. One side assumes compliance is simple, the other knows it's conditional. He asks for help in the most basic way, not accommodation in theory, not policy changes, just assistance in the moment. The request is calm, grounded, ordinary. That's what makes what follows so stark. The response doesn't come as refusal at first, it comes as redirection. Another office, another desk, another building. Responsibility shifts sideways. No one owns the problem long enough to solve it. Rules are introduced, not laws, not explanations, just rules. They arrive without context and carry the weight of inevitability. When rules are presented this way, they're not meant to be understood, they're meant to end the conversation. He explains himself again. The explanation doesn't change, neither does the answer. The device he depends on becomes an obstacle in their eyes, not because it poses danger, but because it doesn't fit neatly into their process. And when process is treated as sacred, anything that disrupts it is framed as a threat. Someone invokes authority that isn't present, a decision made elsewhere, a directive written by someone who doesn't have to stand here and enforce it. The power flows downhill, but responsibility does not. He asks a simple question, not confrontational, clarifying, the kind of question that should slow things down. It doesn't. It tightens the exchange instead. Now the balance shifts. This is no longer about navigation or access, it's about compliance, about surrendering what makes entry possible in order to gain entry, a contradiction that no one acknowledges out loud. The people enforcing the rule do not raise their voices. They don't need to. The environment does the work for them. Metal detectors, uniforms, posted notices, all reinforcing the same message. This is not a space designed to adapt. He points out the obvious mismatch. He cannot do what they are asking without losing the ability to function inside the building. The response doesn't change. This is where escalation becomes quiet, not louder, quieter. The conversation narrows, options collapse. A document is produced. It exists physically, but not practically. It's handed over without consideration for whether it can be accessed. The act itself is treated as sufficient. Delivery becomes more important than comprehension. He asks for it to be read aloud. The request lingers. It shouldn't be controversial. It is. The refusal doesn't come with hostility. That's what makes it effective. Neutral tone, flat delivery, no visible malice, just denial. This is the moment the door closes, not physically, but functionally. From here on, entry is conditional on surrender, and surrender would mean giving up the very tools that make the space navigable. Others arrive, cameras, observers. The dynamic changes, but the outcome doesn't. Presence adds pressure, not clarity. He tries once more to slow it down, to bring the interaction back to reason, to get someone, anyone to take ownership. The effort goes unanswered. At this point, the building itself feels aligned against him, every rule, every barrier, every indifferent gesture reinforcing the same conclusion. Access is available, just not for him, not like this. The denial is never framed as discrimination. It doesn't need to be. It's framed as policy, as order, as neutrality. That framing is what makes it durable. He is told again that he can enter if he leaves behind what he cannot function without. The offer is technically open, practically impossible. This is how exclusion works when it wants to look clean. The encounter hasn't become chaotic, it's become resolved, and resolution in this case means denial. The power imbalance is complete. The building does not move, the rules do not bend, and the person who needs access is left standing at the threshold. The silence that follows is heavier than shouting, because nothing more needs to be said. Once the refusal is clear, everything that follows exists in its shadow. The conversation continues, but the outcome no longer depends on it. The decision has already been made. What changes now is posture, not physical stance, but institutional posture. The people inside the building settle into certainty. The person outside it is forced to react. He continues speaking, not because he believes it will change their minds, but because silence would imply consent. Words become a record rather than a tool. The officers remain composed. Their calm isn't reassurance, it's insulation. Calm makes authority look reasonable even when the result isn't. Questions are asked, answers are partial, information is offered in fragments, just enough to maintain the appearance of engagement, not enough to resolve anything. The document returns to the center of the exchange. It exists, therefore the requirement has been met. Whether it can be accessed is treated as irrelevant. This is where bureaucracy becomes a weapon without appearing to be one. Responsibility is diffused so thoroughly that no single person can be held accountable in the moment. He asks again for assistance, not to bypass security, not to challenge authority, just to understand what's being used to exclude him. The request is denied again. No one explains why reading the document aloud is impossible. They simply state that it is. At this point, the imbalance is no longer subtle, it's procedural. One side controls space, movement, and access, the other controls only their voice. Observers begin to comment. Their presence changes the tone but not the direction. The system absorbs criticism without reacting to it. He points out the contradiction. Entry is offered, access is not. The distinction matters. It always has. The officers repeat their position. Repetition isn't meant to persuade, it's meant to exhaust. There's a moment where someone acknowledges the higher rule, the one that should override the local one. The acknowledgement lands softly, without consequence, recognition without action. That moment matters because it reveals the truth of the situation. This isn't confusion, it's choice. Choice framed as obligation, obligation framed as neutrality. The refusal is restated, this time more firmly. Not as a debate, as a boundary. He is told to step aside, not because he's done something wrong, but because his presence complicates the flow. The building needs to return to normal. Normal in this context means inaccessible. The camera captures the shift. The conversation is no longer exploratory, it's closing. Language becomes final. Movements become directional. He articulates what this means for him, not rhetorically, practically. Without his devices, he cannot navigate the space. Without navigation, entry is meaningless. No one disputes this. They simply move past it. That's the moment when the denial becomes complete. Not because it's aggressive, but because it's indifferent. The officers don't escalate, they don't threaten, they don't detain, they don't need to. The exclusion is already effective. He remains outside, speaking into open air. The building stands behind them, unchanged. This is where power shows its most efficient form, not force, not confrontation, but refusal wrapped in policy language. The encounter draws attention, but attention doesn't alter access. It only documents its absence. Eventually, the conversation dissolves. Not with resolution, but with fatigue. There's nothing left to say that hasn't already been said. He is not removed. He is not arrested, he is simply denied. The system doesn't mark this as a conflict, it marks it as compliance. Rules were followed, procedure was upheld. What's missing from that record is the cost of standing at the entrance of a public institution and being told, calmly, that access is conditional on erasing your own needs. That cost doesn't appear in reports, it doesn't require justification, it just accumulates. The officers return to their posts. The building continues its day, the denial fades into routine, but for the person left outside, the moment does not fade, it anchors itself, it becomes a reference point for every future interaction. This is how exclusion becomes normalized, not through violence but through repetition, not through shouting but through policy. And once normalized, it rarely corrects itself. After the encounter ends, the silence changes shape. It's no longer the controlled quiet of the courthouse, it's reflective, heavy with implication. The immediate denial gives way to something longer lasting, consequence without closure. Nothing dramatic happens next, that's important. The absence of spectacle allows the system to remain unchallenged in real time. What remains is documentation, footage, names, statements, a record created because resolution was impossible on the ground. This is where the imbalance stretches forward in time. The building remains inaccessible in the moment, but the issue moves elsewhere, into files, into legal language, into delay. The people who enforce the rule are insulated by layers they didn't create, orders they didn't write, policies they didn't question. That insulation is the point. It allows decisions to be made without ownership. For the person denied access, the burden shifts entirely onto the future, proving harm, proving exclusion, proving that neutrality wasn't neutral at all. The irony is sharp. A place designed to resolve disputes becomes the source of one, and resolving it now requires navigating systems even more complex than the doorway he couldn't pass through. The footage doesn't shout, it doesn't editorialize, it simply shows the absence of accommodation where accommodation was required. In that absence, patterns become visible, not just this building, not just this moment, but a recurring failure to adapt systems to the people they serve. The denial wasn't framed as punishment, but it carries the same effect: restricted access, lost time, emotional toll. Those costs don't appear on any sign posted near the entrance. The system will likely respond slowly, if at all. Reviews, statements, legal defenses, none of which change what happened in the moment. And the moment matters, because it reveals how easily rights can be overridden by convenience, how quickly authority defaults to rigidity when flexibility is required. This isn't about malice, that would be easier to address. It's about indifference backed by power. The courthouse continues operating, cases are heard, decisions are made, justice is processed, but access remains conditional. For those who fit the expected mold, the condition is invisible. For those who don't, it's insurmountable. The denial becomes a story told afterward, to lawyers, to advocates, to anyone who will listen, not because attention fixes it immediately, but because silence guarantees it won't. Change, if it comes, will come slowly, through pressure applied far from the doorway where it was needed most. In the meantime, the building stands unchanged, the rules remain posted, the process remains intact, and the question lingers, not loudly, but persistently. Who are these spaces truly built for? The answer isn't written anywhere, it's enforced, quietly, consistently, without explanation. That is the real consequence of moments like this, not outrage, not spectacle, but the normalization of exclusion inside institutions meant to serve everyone. And once normalized, it becomes harder to see, harder to challenge, easier to repeat, until someone stands at the threshold again and the cycle begins anew.